Hi, good evening. Welcome once again to the Gildarie Freddie Kissoon show. We also coming to you live on YouTube, and you can get that on the Guyanese Critic page. If you had a very good weekend, so that I worked very hard. Just came from Blackbush Pole. Lots of work needs to be done there. With the road, I can't understand for the life of me. 7 miles into a farming community. Can't get it right. You need to get it right, folks. I hope that you're having a wonderful day. Please take care on the roadways. We have to continuously encourage our people, push them that they do the right thing, and we're not doing the right thing on our roadways. It's all kind of manner, all kind of things that we believe that we could get away with. Undertaking, speeding, cutting in wrong lane, all kind of thing we're doing, driving up one way. I just went home from using the Mandela to Eccles bypass there. And it's unbelievable that the road is not even completed as yet, and you could see some of the madness there. Why do we insist on doing all the wrong things when we could do the right things? But it is who we are, and that is a sad situation. Once again, we're here to do the people's business, and we're going to talk a couple of things today. First of all, Lula's back, and he's going to become the next president for all intents and purposes for Brazil. We know that he was out for a little while on the investigation in jail. He's back and he's president. We should be paying attention there because his style of management, his policy is much different. We should see some developments in the oil sector and a lot more liberal views and expressions there when it comes to his policies, but may have some impact. It will definitely have some impact in this part of the hemisphere, especially in Guyana and its trade with Brazil. Before I hand you over to Freddie Kissoon, my co-host, I want to also say that sometimes we ask here on this program, what is it that, or why is it that we're doing this? It's very difficult. I have my full-time thing that I'm doing, my gig or my gigs. Freddie Kissoon is also full-time columnist, and he has his life to live. But we do this day in and day out, or 3 times a week, getting into our cars or calling people during the day. It takes a lot before we even come here for this to happen. Guests have to be called and so on. We do it because this country, we believe that our voices need to be heard. It's either us or somebody else. We will play our part. I will play my part. Freddie Kissoon to probably tell you a little more on his side. But our country is pretty young. There's a lot of work to be done to raise the bars if we want to really, as I always said, to become a first world country. It takes a different kind of people, take a different kind of mentality. It takes some discipline on our part. A whole lot of attitudes will change. So we're doing it. I'm doing it because I can't stay silent and allow things to slip by. That's not the kind of legacy that I want to leave. That's not the kind of things or the kind of lessons that I want to teach my children. And I have some abilities. It may not be to the university level, but I do happen to have some experience, and I want to use those experience to not only educate myself by sitting here, but also to share with my people some of the thinkings of what happened across the world to improve this country. Without further ado, I introduce you to my host, Freddie Kissoon, and he is going to introduce very charismatic young man. I say young man because I know his family very well, and I've watched him with his legal career, and he has not been unafraid to say the things that he says from time to time. Freddie Kissoon.
Good evening, wherever you are. As I say often in this program, social media reduces the world to a small room. Now, after that long introduction with Gildarie, let's cut into Ronald Burch-Smith's time. Ronald Burch-Smith is one of the lawyers that I have always had an appreciation for. And I have this little thing, every time I see him and his wife, I would go up to his wife and say, why did you marry a lawyer? Lawyer are lying people. And so I was with my dog in the national park, and I saw him and his wife. And I went up to her and said the same thing. And then it occurred to me, if there's any lawyer we should have on this program, or if there's anyone to speak about the rule of law, apart from the Attorney General, it should be Ronald Burch-Smith. So I went up to him and I said, Ronald, you have to come on this program. And he agreed. Now as the program unfolds, you're going to have some interesting things to say about the rule of law that you probably did not know before, whether you're in Guyana or elsewhere, Iceland, Afghanistan, in the diaspora. Some interesting things are going to come out. So our guest this evening is nationally known attorney Ronald Burch-Smith, who comes from a legal background. His father was a judge. In case Gildarie doesn't know, I taught Ronald's sister at UG. I can't remember if I taught Ronald. I don't know. Can't remember. But Ronald, you need to know, he has also a master's in international trade policy. That kind of thing is, the discussions on international trade in Guyana is now ubiquitous. Without further delay, Ronald Burch-Smith, as I would call you, Ronald, on the program, nice to be here.
A pleasure.
All right.
Thank you for having me.
My first question, Ronald, will involve a little commentary, and then I'd love to hear your take about the rule of law, and if there aren't characteristics of a banana republic in this country. I read, Ronald, that former Minister Annette Ferguson won judgment against Vice President Barra Jagdeo for want of filing a defense. I've also read that Enrico Wilford, former NCN General Manager, won judgment against Dr. Leslie Ramsamy for failing to file a defense in the libel writs. I've also seen the former President Ramatau won a libel against Skype Show News, Bassington, etc. Now, interesting, Ronald, I wrote a column when I got sued for libel by Dr. Ramsahoy, Walter Ramsahoy. Fine, I get libels all the time. I've been 34 years in the media. But then it was brought to my attention that Dr. Ramsahoy went on CNN, Sharma television channel, and was discussing his libel writ against me and gave a litany of derogations against me, how I don't have a university degree, I'm a fake academic, all kinds of no scandalous things. So I said, this can't go on. He sued me for libel, and then he went on TV and said horrendous things about me. So I come to sue him. Ronald, the two libel writs were heard the same time in different courts. Justice Gregory Don Barnes heard Ramsahoy writ against me, and the current Chancellor heard my writ against Ramsahoy. Justice Barnes ruled in favor of Ramsahoy and awarded him $2 million. My case was concluded, and now it's 7 years. I have not heard anything. My lawyer has not been contacted. Over the past 7 years, I asked her what has been going on. She said she heard nothing, and the matter just died like that. How could that be fair, Ronald?
Well, from what you described, Freddie, I think it's easy to see that the evenness that one expects in the courts hasn't really obtained in your case. There's currently a significant amount of commentary about the time it's taking for judgments to be given. And a lot of the commentary on it has been critical of judges. Obviously, for a practicing attorney, it's a bit of a dangerous ground to contribute to a discussion like it, but I can set out what the general principles are. Now, generally speaking, a written decision is tied up to a principle called the right to reasons. Now, whether you're in a court or dealing with an administrative tribunal or something like that, you're entitled to know why a decision has been taken that is adverse to you. And so judges are expected to give reasons in their decision. obviously because of the constraints of time and circumstances, sometimes the decision may be a short one, or sometimes it may be a long one. But no decision obviously breaches that right. And you can't say that you've had a fair trial or a fair hearing if no decision has been rendered in your case. In assessing the reasons for the delay in providing decisions, very often the judge is just castigated. And of course it's not my job to defend or explain why any particular judge hasn't given reasons in any particular case. I can speak broadly. I know broadly the judges find it overwhelming. Of course you'll disagree immediately, perhaps correctly, that no matter how overwhelming the circumstances are, a delay of 7 years from the time of the conclusion of the trial to now is unfair. And you'll be surprised at the number of cases that sometimes end with a decision, and end with a trial ends, and then no decision is given. So there's a need to correct that wherever it exists. One of the weaknesses in the Time Limits for Judicial Decisions Act, which the Attorney General was referring to last week, which requires by law that a judge give a decision in 4 months, is that it doesn't take into account what the judge's work schedule.
But these are written decisions we're talking about, right?
It just says decision, so a written decision doesn't have to be 20 pages. I mean, when we were going to school, the judges who were highly regarded and respected for giving wonderful decisions, Messiah, Bishop, J.O.F. Haynes, Chancellor George, and so on, they were beautiful decisions. You know, they were essays and dissertations on a particular area of law. But when you look at the dates that it took for them to write that decision, it took a year. Now, everyone who is a lawyer or a judge, you know, would love to be respected by his or her peers by writing, you know, comprehensive decisions, explaining it and expounding on principles of law. But most cases don't require dissertation on the law. They require an analysis of the facts, which could be 2 or 3 pages. It requires a statement about what the law is, which is another 2 or 3 pages. So you can give an excellent decision in 5 to 10 pages. It's difficult. I mean, the judge is hearing a case, at least one case a day that's concluding. And the time it takes to write the decision a day doesn't really not exist. So this is the weakness in the Judicial Time Limits Act, that it doesn't contemplate the judge's workload. I'm not excusing your circumstances. From what you've described clearly, a lot has gone wrong there.
But I would like to know why I lost or why I won. The points there. So it could be used in other libel cases. It could be used in teaching at the University of Guyana. Where did the libel onus fell on? Dr. Amsar? Why was he exonerated? I'd like to know what happened there.
You're quite right, because in your case, as I recall, I think I was in the Court of Appeal when the decision was given there and the damages were increased. And then in the CCJ, I think they were reduced a bit. So it's certainly interesting to juxtapose the case against you with the case you brought. I mean, clearly it's unjust, but the system is far from perfect. We've implemented new rules in 2016 that have improved the pace of litigation, so now that day in court comes faster. If you file that's not a writ anymore, you file a statement of claim now, you can reasonably expect to get before a judge for a trial in 12 to 18 months, or at least to start the process. Of course, it might take a year to actually
conclude the trial. It's an interesting question that Freddie has asked here. I remember going to court a couple of times, High Court especially, and I couldn't believe a couple of years back, I think it's changed now, there's some speakers and so in those places, but vehicles passing up and down, and minibus, I think one judge had called to send the policemen at one time to bring in the minibus people who were causing some ruption outside with their horns. But you're in the court and you see the kind of things, how laborious it is. Imagine the judge is writing and then there's thing, and then you got to go back and you're listening straight into here. You're sitting on the benches, Freddie Kissoon, and you're trying to listen to the judge, and it's so difficult. And I take what you're saying there. However, it does not excuse why. I could tell you that an amplifier system, and I couldn't understand for the life of me how come we couldn't have a recording system that instead of a judge going back and forth all the time?
I understand it's been here since year before the last.
So
They have some
prior
systems
to,
now.
Yeah, it's been,
Right.
prior to COVID, the judiciary has implemented a system for the electronic recording of cases. The objective of it principally was to relieve the judge of the burden
Right.
of writing notes. As I understand, following the implementation of the system where it's available and you can request a transcription, some judges have found that that the transcriptions sometimes are unreliable or they're not available in a reasonable time. And so many judges have defaulted back to the practice
Of writing.
of taking evidence with their own handwriting. Now it's impossible to maintain an efficient speed if you have to write everything. It's just not possible. Now, my own opinion is that instead of an electronic system of recording, we should simply get a courtroom stenographer
I think
so
so
that
too.
the transcript is available to the judge in real time. Well, that can be backed up by a recording because a lot of the modern courtroom typewriters
Yeah, the ladies clicking with fingers all
right,
the time. Yeah.
they have a recording function as well.
what-
You'd obviously have to pay the person a pretty good
Well,
salary.
you have to.
It makes no sense to have a judge who, pick a number, let's say the cost of a judge per month is $10 and the judge is spending most of his time doing the work of someone whose skill and experience
That's the thing that baffles me. How do we have that?
$2.
I want to,
So
if you're viewing this program, we're coming up now to an interesting point. I've always, after what I've been told 5 years ago, I've always regarded Ronald Burch-Smith as a very brave lawyer. Not many lawyers go in that direction. And I do think that direction he went to was very courageous. And so we're going to touch on an interesting piece of history, current history in the rule of law. For 5 years now, I've been going back and forth with Ronald about whether I should write about this thing because he's a lawyer. I am not, and I don't want to be sued. I've never written about it. Ronald Burch-Smith is now in the studio. There are thousands of people looking at him, so I will ask him now. You took Attorney Joe Harmon in front of the Legal Practitioners Committee, either for discipline or to be disbarred. That is a very courageous act. You want to tell our viewers whatever you want to say about that?
Well, Freddie, you've asked me about it several times. I don't think it was particularly courageous. It was circumstances where I didn't really have a choice. A young colleague was instructed by a gentleman who had already made a complaint against Mr. Harmon. And my young colleague was reluctant to do it himself. He had just come into practice, he wasn't sure what to do, he didn't want to take on that responsibility. So he asked me to do it and I couldn't think of any reason why I would refuse. So we filed a complaint. It came on for hearing before the Legal Practitioners Committee. The Legal Practitioners Committee is called LPC. It's a committee made up of lawyers who hear disciplinary complaints. And the committee is administered through the Court of Appeal from the Office of the Chancellor. So the Chancellor's Secretary is the Secretary of the LPC and they manage it. They have 2 panels of 6 attorneys each. And so they heard the complaint. Mr. Harmon didn't lead any evidence on his own behalf. The hearing finished around the time of the 2015 general elections. I believe we discharged our burden. I fully satisfied we proved their case. There are a lot of questions that Mr. Harmon could have answered if he wanted to, but he never answered anything. He didn't say anything. He didn't participate in the proceedings. Well, his lawyer came, but he didn't lead evidence on his own behalf. They've never given a decision. And this is now 7 years?
7 years.
They've never given a decision. Now, if they give a decision, they can make recommendations. If they consider the complaint sufficiently serious, the matter can be referred to the Attorney General for him to disbar a lawyer. I think we need a new system, a different system which takes away from the Attorney General that sort of responsibility. It takes it out of the hands of the Chancellor to manage it. We establish a permanent disciplinary tribunal, appoint a chairman, and have a smaller panel of maybe 2 or 3 persons, draw from either the magistrate, judiciary, wherever, and get on with complaints. Because just as in your case, Freddie, where you finished the case 7 years ago, and you don't know whether you won, you lost, Dr. Amsahoy is no longer with us, you never heard again. The gentleman who I represented is quite distressed. He spent money, he came from England, he gave evidence, he brought witnesses, he instructed a lawyer, and in 7 years the Legal Practitioners Committee has never seen it fit to communicate with him.
But hold on, Ronald. Isn't the reason for that, I have written about this in one of my columns several years ago, could the reason for this be that those 6 men that sat were lawyers who probably knew Harmon, probably had interaction with him? Why not an engineer, a priest, a medical doctor? That's 3, and 3 lawyers. So the medical doctor who don't know Harmon would say, listen, on this evidence, no, I think, was it a very serious charge?
Well, at the time in which the case was going on, Mr. Harmon was not yet a Minister of Government, but by the time it concluded the evidence, he was a Minister of Government. And so, I would be naive, Freddie, to say that my colleagues who heard the case, that it never crossed their mind that, there might be some inconvenience to them by making an adverse ruling against Minister Harmon. But lawyers have taken an oath to uphold the law. And if we could demand that the police uphold the law without fear or favour, we complain about politicians not upholding the law fear or favour. When it comes to judgment of our own colleagues, we certainly have an obligation that I think trumps, currying.
Thank you very much.
Ronald Burch-Smith, tell me here tonight. No, I'm not directing this question to you. I'm directing this question now to Gildarie. Gildarie, are you happy that 6 engineers, 6 vets, 6 lawyers are in charge of arriving at judgment in a complaint? Are 1 vet against another, and the 6 vets are the judges. 1 engineer against another, and there's 6 engineers. Are you happy with that? Don't you think there should be some extraneous?
But it's a good question. Let me answer this way, and I think for all practical purposes, Freddie, and maybe Ronald the counsel could probably agree there. Freddie, how do you put somebody who doesn't know law, who's not a lawyer, to be sitting down and looking at legal aspects of something that concerns a man? It has to be somebody within the legal profession.
No, that question could easily be answered.
How?
You have a jury system. The jury convicted.
Well, you need somebody to direct them. These are 6 people who are sitting down listening. I think really it should not be 6 persons. It could probably be more. But how do you put people who doesn't have any legal background to judge somebody or to decide on somebody who in the legal field?
How could you ask a person to be satisfied that they complain against Dr. Igublu, and 6 doctors are hearing the case against Dr. Igublu? Don't you think?
It's a different thing. I don't think you can draw the same parallel.
No, but the same thing with the lawyers, yeah.
Not in the legal profession, I don't think so.
Yes, it's the doctors who hear a complaint against doctors in the medical Practitioners Association.
I got a spin-off question for that. Well, Ronald, you could probably, my question there, because Freddie has raised a very good point there. Could it be possible that you have a committee which could be made up of people who are not in a legal background to be able to judge?
Like university professors, sociologists.
So, I think the main challenge is the complete absence of any accountability. Now, it may be that some of it is structural. One of the things you suggested is a smaller panel so they can be more efficient. It's easy to get a quorum and get on with the job. The other aspect of it is that Freddie raises is legitimate, that are the persons who are judging necessarily impartial if they're also lawyers. And I think there is some merit in that observation. Perhaps it is that the panel should be differently composed, so not necessarily lawyers, but somebody who's completely outside of the system who can sort of give it some level of accountability. But the idea that you can have a system where a panel of volunteers is given important work, the life of that panel expires arbitrarily, some 2-year period, and then nobody does anything, nobody's responsible, nobody cares.
So Mr. Harmon is free. That matter is
But
finished.
it's not a criminal. The tribunal doesn't have criminal powers. The tribunal can only make recommendations or sanctions.
No, so there's nothing about that anymore. It's dead. It's dead and gone.
Well, 7 years, the life of the panel is long expired. You're not going to get a judgment.
I want to draw a parallel. I'm going to say something on this program here, which I wrote about as a columnist. I'm not sure if anybody has read it, or a lot of folks probably don't know. My two kids were taken to a pediatrician at a particular hospital, and the doctor who's been treating them, that pediatrician, who's been treating them for years, since very small, decided they had a particular condition. He suddenly discovered that condition. And we went through a series of tests, expensive tests, while I was a reporter. When the test came through, I questioned how he arrived at that decision, that how he believed that he got this condition. Because you were treating them all the time, or you were looking after them all the time, how did you arrive at that? I made a complaint to the medical, I think it's a medical body.
The medical council.
Right. Here the kicker is, I want to take legal actions, and I asked a couple of lawyers. I also met a couple of doctors. Everybody know that, or there's a feeling in Guyana that most of the hospitals run a racket in which they send you to do unnecessary tests and cost you a whole bunch of money with poor people. And they believe that there's a racket to do that, and all doctors are involved, so nobody goes against. If you go to the medical body and you go complain to them, their peers, it's very difficult in Guyana to find anything unless they don't really like you. One peer or one doctor coming against another doctor.
Yeah, it's a caricature.
I rather suspect the same thing in Guyana. While we're in competent forms, I am going to find it very difficult, because if I muddy his water, the muddy water could spill over on me. That being the case, I want to ask you a case directly. When it comes to, you mentioned the Legal Practitioners Committee. Do you know of the incidents, or could you know the numbers abroad in country, let's say the United States, in which there's sanctions against lawyers? And when you look at the incidents in Guyana or the number of complaints, do you have any idea where it's a lot in Guyana as compared? Are the percentages here?
I'm not sure I don't know anything about actual percentages, but what I do know for a fact is that in the United States and England and developed countries all around the world,
there's strict rules with those.
No, lawyers are disbarred every day, right? I know that in Jamaica they disbar at least maybe 3-4 a year.
3-4 years. Do you know for the last 3 years?
I know
I don't know of any lawyer that's been
Barbados
disbarred.
they disbar lawyers. I know they've got criminal convictions against lawyers in Barbados. I'm
Could
not
you
sure about
could you
Trinidad.
recall in the last 3 years if any lawyer has been disbarred, or whether?
As far
No, but
as
tell us which lawyers
As
were
far
banned
as
and
I
how
know,
many.
as far as I know in Ghana, no lawyer has ever been disbarred.
You why not? You know why I asked him that question,
I don't want to laugh.
All right. We come to a very but you understand?
But he's laughing.
No, but you understand why I'm
He's
asking that
laughing.
question? All right, we come.
Sorry, there's a bit of a nuance here, to be
Yeah.
honest. Some of the complaints in Jamaica and Barbados that have led to lawyers being disbarred relate to their system of conveyancing, where lawyers hold the proceeds of sale of a building, right?
Mm.
So you're selling your house to Freddie.
Mhm.
I receive the money and I keep it for a year or however long it takes to complete the conveyancing, and then I pay it out to Freddie, right?
Mm.
Now I have to account for the money, and in those countries lawyers receive huge sums of money that they very often run into trouble with managing.
Mm.
They mix it up with their own money, they spend it, they can't account. Sometimes it's a lot of money. So the system has a problem that's different from ours. A lot of the things that have led to lawyers being disbarred involve huge amounts of money where there's really no explanation, it's very difficult, and so it's very easy to get to the stage of disbarring a lawyer. That said, it doesn't mean that lawyers in Ghana don't misbehave from time to time, or that there are no other circumstances which justify lawyers being disbarred. But that sort of egregious conduct that leads to disbarment in those other Caribbean countries does not happen here. In fact, I remember an encounter with a leading lawyer in Jamaica, who I think was holding some government office at the time, Solicitor General or something, who was so impressed with our system of conveyancing that protects vendors and purchasers of property that he wanted to study it, to consider adopting it in Jamaica for implementation. So, I mean, that caveat is important. I mean, so we're back, but there are some things that don't really happen in Canada.
But very interested. Something happened the last couple of days, Council. I think the whole of Guyana was paying attention. I can't remember for a long time on a particular issue that I saw so many people in total agreement, and they were heavily criticizing SOCO. So here the thing is, you, each and every citizen of this country, if you are arrested by the police, I'm trying to put it in layman's term, you should be advised that you have rights. You could get a lawyer. If you can't afford one, I think one could be provided to you. I think in the States they call it the Miranda rights are being read to you. Across here, if you don't want to say anything to the arresting officer, you could wait on the lawyer to come. So a lawyer goes into SOCO and she's representing her client, at least that's how the story comes out. And she told the client not to say anything, and she was arrested. In SOCO, and the Attorney General and got into act because I think complaints were made to him, and he instructed the police, or advised the police with the SOCO, to release that lawyer. But by the time the story hit the news, there were widespread condemnation. Counsel, my question to you: is this widespread in Guyana, that kind of behavior, and what are your thoughts about because the Bar Association did come out and issue a statement, what are your thoughts on the lawyer? And we're going by the story is being told. The lawyer who was arrested because she advised her client, don't you say a word.
So there are two sets of rights involved here. Firstly, it's the right of the person who was being detained at SOCO, who was being interviewed. The Constitution provides that you have the right to access to your attorney. That right is enshrined in the police standing orders, so the police are aware that this is something that they're expected to follow. And we also have something called the Judges' Rules, which we adopted in 1964, patterned after Judges' Rules that were issued in the same time. But of course, Freddie, Gildarie, you'd know that the system of justice that we enjoyed, it was not always like this. There was a time, in England, where you didn't have the right to not answer questions or to protection against self-incrimination. Particularly during the period where there was a lot of harassment of Catholics and the drive to cause the Anglican Church to become entrenched in British society. You didn't have the right to remain silent. In fact, you had to swear an oath at the beginning that you would answer all questions that were being put to you. But that, of course, has ameliorated over time, and the rules that we adopted in 1964 are still in force. Of course, in some countries, the right to not incriminate yourself has been modified. So, for example, in England now you're warned that you have the right to remain silent, but if you fail to say anything that may later on be useful to you in your case in court, that you didn't say so now may be considered by that court, right? So it's not an absolute right that you can remain silent and nothing happens. But you can make that election. It's still, if you wanted to do so, but there may be consequences. Nobody can stop you. So that's the rights of the person affected. In the US, of course, their version of it is known as the Miranda rights. That's what we see mostly on television. And there are broad similarities, right? In the US, of course, and Guyana, if you are not allowed the protection of those rights, Miranda or the Judges' Rules, a statement or a confession obtained by the police is inadmissible. In relation to Ms. Clark, the attorney at law who was arrested, she also has constitutional rights. So it's not just the rights of the litigant that are affected, it's her own right. She has the right not to be detained unlawfully. And nothing that I know of that was described in the report justifies Ms. Clark's detention. I'm not saying it's right, but if the policeman thought that he didn't want her there while he was going ahead to question, and he was satisfied that circumstances existed, I don't know what they could be, but he was justified in excluding her from the station. He would go back to questioning the person. That would be one matter. But adding to that, the arrest of the attorney is another matter. Now, I don't know which is more egregious. Interfering with an attorney's work, intimidating the attorney, arresting them unlawfully. I think there's this view that the police have that this power of arrest is something they can deploy at any time when they feel like. But arresting a person is a very serious act. And arresting a person arbitrarily for stupidness is a serious problem in this country.
Is it prevalent? That's what I'm trying to determine.
The police abuse it. They arrest people unnecessarily all the time.
The human rights, the civil society groups, the media, and so many people in this country do not know what ordinary people go through. But here is a dimension that I want to bring in. I understand it, and now you please correct me. The lawyer has a right to the client. But if the client doesn't have a lawyer, the mother, the uncle doesn't have a right to go to the station and speak to that.
So particularly for young persons, the same judge's rules provide expressly that before the police interview a young person, which is, depending on which act it is, it's defined differently. Let's say on the 16th for the purpose of this discussion. They can't question a juvenile or a young person unless in presence of a parent or a guardian or that person's attorney.
The police is chasing away the people's parents.
Well, if you're speaking about an adult, I mean, if I'm 21 and I'm in police custody, under the judge's rules, there's no right to my mother to see me.
If they don't have a lawyer?
Now, if a lawyer is there, I'm entitled to consult with my lawyer. Now, in the judge's rules, again, when they're going on to taking an actual statement, you're warned not just that you can have a lawyer present, but you can have a friend or any other person
okay, that's
present.
what I'm getting at.
This is where I'm about to take a statement. But if the police aren't actually taking a statement from someone in custody, the law doesn't expressly say that if your mother comes to visit, that I have to let her.
No, this has to be repeated. This has to be repeated for our viewers. This is something people don't know. And I found out about it, and I would like him to repeat it. Here is what he's saying. Here is what one of the most prominent, knowledgeable attorneys in Ghana is saying. The police has John Smith in the station. There's no lawyer or anything. The police now is taking a statement from John Smith. The lawyer is saying...
There's a distinction with the age. So
no, he's saying anyone. They're taking a statement. They're taking a statement from a 60-year-old, 60-year-old. There's no lawyer. Once they're taking a statement, he is saying that that accused has the right for a relative or a friend to be there. Isn't that so?
Absolutely. Now, what you'll find
a lot of people don't know that. I found that out.
Tender statements under caution, they call caution statements. Almost invariably, the person has never made a request. Never made a request to complain. So apparently people are just chatting away with the police, told that you can have someone present, and they never ask to have, their mother, their cousin, their auntie, their girlfriend, their boyfriend present.
I want to ask you a question directly. Is it very prevalent that the police, the arresting officer, the person who's taking statements, do you have knowledge or were you told, and is it very prevalent that they don't advise the suspect or the person that's taking statement of the rights?
I don't know.
You don't know?
No. Well, in Ghana, one of the problems you have in society is that because so many persons don't have resources or are not well educated, you may find that the police treat them differently, right? So what I may experience if I go to the police station may be vastly different from what another citizen may experience. So, I go into the police station, especially if I'm dressed in court clothes with a jacket and tie. The reception I get from a police officer is not going to be the same as a man who might have been standing at the side of the road selling water or waiting for a bus in tattered clothing, right?
You can't remember. It's more than 5 years ago.
That's not right, but I know that's what happens frequently.
No, it is. It is a fact.
You can't remember, but this occurred on the telephone conversation we had. And I think the law is called the Administration of Law Act that was brought in when Mr. Burnham ruled Guyana, in which you could be charged with $500,000 or $1 million or some indicted, some serious crime, but you go in front of a magistrate. And I think you were telling me that I should investigate that or write about it. Please expound on that now. Please explain everything.
Right. So there are, broadly speaking, two categories of criminal offences. Some are summary offences and some are indictable offences. Indictable offences are the more serious, murder, manslaughter, wounding, rape, etc. Summary offences are like, minor stuff with traffic, a small amount of cannabis, petty larceny, that sort of thing. But then in the middle, there are some offences that are very serious, but could also be tried summarily. That's what they call the hybrid offences, or offences that can be tribalized.
Then you could opt to go to trial, or you could...
Well, you don't have the election. The court really makes a decision. Now, the power of the magistrate to decide to try you summarily for an offence that is laid indictably is found in something called the Administration of Justice Act in 1978. The purpose of the act was to relieve some of the burden on the High Court, where trials have to be done before a jury, they take a long time, they involve a lot of resources, etc. And so it was felt that it was best for some of those at the lower end of the spectrum, of the indictable offences spectrum, for some of those to be dealt with in a magistrate's court. But what you find right now is that unless it's murder, manslaughter, or rape, you never see a judge. So you can be charged for armed robbery, you can have 25 armed robbery charges, and you'll never get charged, you'll never be tried by a judge. You'll always be tried by a magistrate. And magistrate's jurisdiction, power to sentence you is limited to 5 years. So you stick up someone with a gun in this country, you will get 5 years. There's a system where there's an automatic discount of a third because of overcrowding in the prison. So that 5 years becomes 3.5, guaranteed. And if you don't make trouble, you could get out in half the sentence.
And it's a violent crime you've been charged for.
You rob someone with a gun in Guyana.
That is 1978. What have you been doing when you were president of the Bar Association? What all the other presidents of the Bar Association been doing? That is wrong. You could be sentenced to 15 years for chopping a person with a cutlass and robbing them. And you go to a magistrate and she could only give you 5.
So what you find that happens, and this is not just for violent crimes, this is also for serious crimes like trafficking in narcotics. We have not attempted to try anyone in the High Court for trafficking in narcotics since the late 1990s.
That was M.V. Danielson, I think, all those things. There was a couple of big cases.
There was one particular case that didn't go well. And since then, no person in possession of any quantity of cocaine has faced a judge. So you can have 1,000 kilograms of cocaine. You will not get a day more than 5 years. So in Barbados, they've recently amended the law in relation to firearm, or there's a proposed amendment, I don't think it's passed, where if you're charged with a firearm offence, your minimum sentence is 15 years on the first offender. Right? Now that might be harsh, I don't know if that's appropriate, but robbing someone with a gun is a serious crime. It should be met with a sentence that exceeds 5 years, whether you're a first offender or not. I mean, in my view, you should probably be looking at something closer to 10 years, right? As a first offender. As a repeat offender for a firearm offence, you should be looking at a sentence of 15 to 20 years. The law provides for some of those serious offences like wounding, firearm offences, for terms of imprisonment like 14 years to life, right? But we have effectively capped punishment for a whole range of serious crimes in 5 years.
That includes death by dangerous driving?
Yes.
So a man drives on the pavement and kills 5 people.
He could go plead guilty and get 5 years.
You know, Ronald, please talk to us about this thing. Please talk to us about horrible, unimaginable crimes. And once you plead guilty, there's an automatic substantial reduction. Why even if you plead guilty, you cannot get, when you plead guilty, you cannot get 30 years. You cannot get, I see 2 youths chopped up, a man and his wife, robbed them in Berbice and chopped them up to death.
I am not sure what the policy is regarding guilty pleas in the High Court. I think we clearly need some amount of reform where there can be some statutory guidance. As it is right now, it's entirely a matter of judicial discretion, and you have results that vary widely from judge to judge, which should not be. It should be more or less uniform regardless of which judge you go before. Now, the state has an incentive to secure a conviction, even if it means that there's some sort of compromise on the punishment. By law, if you plead guilty at the first opportunity, you will get a less severe sentence than somebody else. In many instances, you see that notwithstanding a guilty plea, the judge still imposes a severe sentence. I don't know the particular case you've described, but if there's a serious violent crime, unprovoked, in course of a robbery, regardless of whether you plead guilty or not, the sentence should probably... What was the sentence?
I can't remember, but I know it's that Guyana is replete with people committing really serious offense, and they plead guilty. And what viewers have to note is that a year is 9 months. So when you see the person get 10 years for a heinous crime, it's not 10 years they're going to serve.
Well, it's between
3 months coming off each year.
They will serve between 3 and 4 years, or maybe 6 and 7 years. So, so there are two sets of what they call a discount on the tariff, on the sentence. The first is time served. Because it takes a minimum of 5 years for you to get before a judge, or in some cases 6, 7 years.
So discount that right away.
That is discounted. So if you see a sentence of 10 years, effectively it's probably a sentence of 15 because there was a discount for the time served while you're waiting on your trial. I don't know what the factors are. It may be the judge considered the age of the offenders, that they pled guilty the first occasion. You can have a heinous crime, the person pleads not guilty, they go to trial and they're acquitted. You can have a situation where a person says, well, I wouldn't put you through the expense or risk of a trial, I will plead guilty. That person gets a discount on their sentence.
But the question is, how much is a discount?
I don't know the particular case that
there's so many that, well, I can't begin to tell you, there's so many.
If you have 10 criminal trials and 10 sentences, you will find statistically that 2 or 3 of them might be at the lower scale, where me or you in the position might have considered it deserved a higher sentence, right? That will happen. System is, it's not a mathematical process. There will also equally be 1 or 2 at the high end that are probably a bit higher. The idea though is that for the most part the majority should fall within a range that we can all agree is reasonable.
Do you believe that the 1978 Administration of Justice Act should be amended?
Absolutely. I think magistrates' jurisdiction should be increased to something like 7 or 8 years at least, maybe even 10 years. I believe that there should be some reform in the way we view serious crime. If you commit serious violent crime, and this is armed robbery, robbery with a knife, robbery with violence, your minimum sentence should be 10 years.
Well, the problem that you have, and I found it, Freddie Kissoon, you can have a man commit, and I think the good counsel would know this too. You have a man in Berbice commit, or he goes to Berbice, commit the crime, and then you go to Demerara and you commit the crime. You appear in the magistrate court. The records are in such a disarray. By the time they catch themselves, then they realize that the man has other matters. Sometimes you'd hear next week come back, well, he has other matters. But imagine you commit 2 more robberies in Berbice, and this is where the situation gets very dangerous. And also, for me, I find it very difficult to comprehend for somebody who's been robbed or somebody who's really suffered at the hands of these guys, that you see a man commit six robberies. He commit 3 of these courts and 3 of these bank, and he go into court there, being placed on bail there, go and commit up these bank there, and being placed on bail there. But nobody takes into account the fact this man is a serial offender. Maybe, well, it's allegedly at the point in time of the trial. But the problem that we have is a broken system, and it all comes back not only because you release people only because it is a policy of government, but also because you don't have proper record keeping system. It's not digitized. So you have a bundle of problems that's happening in the court, and all of it comes back to the end of the day to less justice for the people out there.
I think, Freddie, allow me to say this, and this is not really intended to be a criticism of any particular person or a political party. In our country, we don't see some of the problems as being systemic or being the result of an absence of a comprehensive policy to fix it. So, for example, the lawlessness on the road, we consider that that is a function of individual decisions. You know, I made a bad decision, you made a bad decision, Gildarie made a bad decision, right? Not necessarily that it's systemic. So, for example, do you know that the third-party limit for insurance, the minimum that you're required to have is $25,000? $25,000 can't buy a headlight for any car. If somebody hits your car, the minimum insurance they're required to have is $25,000. Now consider what is the likely result of an accident involving public transportation or a serious accident. An average car, talking about a teacher, nurses, you know, whatever is the modest car that those persons buy. The best they can get from the insurance company is $25,000. Now ask yourself, is this a function of an individual decision to behave badly, or is this a function of the absence of an effective policy from the state? And if you start with that, you'll easily find that a lot of the problems on the road are systemic. The way the roads are designed, the way traffic laws are enforced, the absence of an efficient system for ticketing and the collection of ticketed fines, the way we allow parking and driving on the road. All of those are broad policy areas, but there's nobody who is responsible for policy. Take your pick. Insurance, better regulation, providing resources to management. The discussion about bad driving never involves the absence of policy. And there's a complete absence of policy. I think the same can be said for the criminal justice system. We perceive that a person who goes out and commits 20-25 robberies is because he's a bad person. His mother's a bad person, his father, his community is failure. So the finger is pointed at the person, their community, and whatever else you want to do. Not that, well, we have failed to provide victims of crime with adequate protections in the law. How can you have a system where a handful of men can commit 20-25 robberies before they're convicted, and then they get convicted and they serve 3-4 years? That's a systemic problem.
For 10 robberies.
That's no longer a problem of his community or his mother or his school or his friends. That's a societal systemic failure.
Tell us tell us as the time go. I think I looked at my mango pelter, and we have 8 minutes more. Let's see if we can get in as much from you in the 8 minutes. Tell us what you would like to see in the improvement. One, the rule of law, the shape of the judiciary, and the general legal world in Guyana. I know it's a big one.
Right. So the reality, Freddie, is despite all that we've said about what we would like to see done differently, at least for any of those things to happen, a decision has to be made about the allocation of resources, right? Because if I had my way with sentencing, we need about 5 more jails, twice the size of the current one, right? Somebody has to pay for it. Also, well, there may be decisions about whether it's fair or right to have so many people locked up, but that's a different problem. But we need resources. You need more police, better equipped, better functioning courts. But I think we're failing at a very elemental level. So, for example, one of the problems with the capacity in the judiciary is the absence of a Judicial Service Commission to appoint judges. Now, that's easy. A Judicial Services Commission could be appointed tomorrow. That doesn't require resources. I'm sure there are applications for judicial office. There are about 5 vacancies. The Attorney General has talked about law to expand it. I think we have the money to pay for more judges. We have the money to pay for stenographers. Why isn't it happening?
It's a will.
Right, so maybe half the problem is outside of our scope, but there's a lot of low-hanging fruit that we could get going with tomorrow. Every person I know that is in the judiciary, the magistracy, and most policemen I know work ridiculous hours. They really are overwhelmed. They work long hours above and beyond the call of duty, for which they're really nowhere close to being fairly compensated. So there isn't a single judge, magistrate, policeman that I can say doesn't work hard. But you need more resources to make the system more efficient. In relation to the rule of law, that's not necessarily in this. I mean, in the general terms, talking about incidences like a policeman deciding it was okay to arrest a lawyer, that's not a resource problem. That's a discipline problem.
And a children problem that.
Well, I can't imagine. I would really love to know what his thinking was that he thought made it make sense. But nothing about it makes sense. It must be that he thought that the rules didn't matter, that there was some objective that would justify him breaking the rules, and he must have felt that he could break the rules with impunity. Because I've never met a police officer who threatened to lock me up. And for a policeman to do that, it must mean that he believes that the rules don't apply to him.
But a magistrate,
I dare you, Freddie.
a magistrate almost ordered a prosecutor to be arrested.
I am not sure. I think those are a bit of different circumstances. Every couple of years, some judge feels that the conduct of a lawyer is such that justifies contempt. Invariably, though, it doesn't go very far. But I'm not sure we're comparing the two things here, right? In those circumstances, I'm sure the magistrate or judge, because sometimes I've gone with persons frequently who judges threaten to lock up. Invariably, it doesn't happen. But usually there's a good reason. The judge can give you an explanation if he's allowed to do so, and the conduct of the person will explain it. I am not sure what circumstances could justify it, except that the officer involved and his superiors felt that the rules don't apply to them.
Something happened, and when it happened, I had a chat with one of Bobby's well-known lawyers, Marcelin Bacchus, and I didn't know. He told me that practice was since after independence. Remember, the DPP ordered a magistrate to proceed with the trial of a murder of accused, and the accused lawyer went right up to the CCJ saying, "You are a prosecutor. You cannot tell a neutral judge what to do." The CCJ ruled, and the murder accused was freed. And Mr. Marcelin Bacchus told me that is something that was on the statute books.
So the law allows
in the 60s.
Right, so the Director of Public Prosecutions is authorized by statute to direct a magistrate to indict someone or to commit someone for trial in the High Court. She has that power. The power is usually exercised after the DPP has read the depositions and is satisfied that the depositions justify that the person should be committed to trial for a particular offense. There are two cases I know where the DPP's decision-making has been questioned. One was Henry Green, where her decision to institute charges was quashed even before the preliminary inquiry commenced. Most commentators view that decision by the late Chief Justice Ian Chang as being perverse. And so I don't really take it seriously. In relation to, I think it's Marcus Bizram, the CCJ would have considered what the DPP's reasons were. So the general principle is that the DPP has the power, but all powers under law must be exercised reasonably. And if I recall correctly, the CCJ's reasoning on the matter was that her decision was unjustifiable because she didn't have good reasons Meaning that the evidence was weak or insufficient? Or
No, wait, Ronald.
This is in
Are
Marcus.
you sure the CCJ didn't rule that she cannot direct a magistrate? I think the CCJ did that.
So the statute says that the Director of Public Prosecution...
And the CCJ said that statute should be changed.
They may have expressed an opinion about whether they like it or not, but the DPP has the ultimate power to direct a magistrate to commit someone for trial.
Or stop that trial.
No. In this case, the magistrate freed Besram, and she ordered that Besram be tried again. Besram lawyer took it up to the CCJ. Now, we had the Attorney General here. We asked him about that, and if I could remember well, I think they're saying that's a mistake in law. The CCJ is saying that's a mistake. You can't have, it's a separation of power. You can't have
So the power that the DPP is exercising here exists in most Commonwealth Caribbean countries, and broadly speaking, the power, it's expected that it will be exercised reasonably. The courts increasingly are willing to find that where it's not exercised reasonably, that the judge should exercise the power to interfere with the DPP's purported discretion. Generally speaking, though, I think most lawyers I know would be of the view that that power is necessary and useful, and most times it's exercised sensibly and fairly. I don't remember enough about Mr. Bisram's case, but I think the problem he had was that the evidence was very weak and tenuous, and the DPP's discretion was being exercised on very slender grounds. And I'm sure in the decision there must be some commentary on the utility of the power, but I am not sure that the CCJ went so far as to say that it should not exist.
Okay, I think I read that. I may be wrong. I'm going to go and look at it. Two things before we go. Do you, as a lawyer, support amendment to the Anti-Narcotic Act? So bail could be granted. There should be...
For marijuana?
Community service, a smaller amount if convicted.
I would support some reform of the Narcotics Act. I think the criminalizing of the use of small quantities of drugs is something that I think is out of step with the time. The current thinking about narcotics in a lot of the world is that it should be treated as a public health problem rather than a criminal problem. The use of dangerous drugs. I have my own reservations about it because unfortunately, as I've gotten older, I've probably gotten a bit more conservative in my views about marijuana. I'm not sure it's as harmless as we make it out to be. Some people compare it to alcohol. You know, if you could drink as much rum as you like, why you can't smoke a spliff? I mean, large sections of the society that use marijuana occasionally and function just fine. But I'm not sure that we properly understand in this country the dangers of marijuana. Brings its own set of problems, right? Just like alcohol has problems with abuse.
Abuse of it and so on.
Drugs has its own problems, you know.
But you support decriminalization of small amounts?
I have never seen a purpose for sending someone to jail for possession of small quantities of marijuana.
How is your dad? I don't think people know your dad was a judge.
No, I'm actually glad you brought it up. No, my father's a farmer. My parents are farmers. My father retired.
Oh, that judge was your uncle?
Justice Burch-Smith was my uncle. My father has 3 sons, and his brother had 3 daughters. So, if you meet any man in Ghana with this last name, it's probably one of my brothers. And if you meet any of my uncle's daughters, well, there are 4 sisters.
The judge, is he?
The judge had 4 daughters.
He's
No, unfortunately, Uncle Desmond passed away a few years ago.
So who for you had a legal background? Why did you want to become a lawyer? From the uncle side?
No, I was a degenerate drinking at the side of the road, and my English teacher, Miss Claire Blake, said I should go and study law. And
Miss Blake was your teacher?
Miss Blake was my teacher. She caught me drinking on the side of the road in Kitty, and she said, Burch-Smith, you should go do law.
And that was it?
well,
The transformation of Ronald
Ms. Blake
Burch-Smith.
was a Jamaican-born teacher at
an English
QC,
teacher.
at Queen's College along with Miss Maxwell.
Transformation of Ronald Burch-Smith. That
Yeah,
could be a
it was-
good play.
I was degenerate drinking Guinness at the side of the road on Friday.
Unfortunately, that's what our lawyers do in
My
reporters as
my
well, except Freddie
grandfather
Kissoon.
was a magistrate.
Your
He was
grandfather.
a solicitor in Amsterdam, and he became a magistrate. And
But now that
my family moved.
Freddie, we out to that.
now that you make this transformation, what are you doing with all this money? From a bar to
Ladies and gentlemen, that is Freddie Kissoon for you. He always wants to know what you do with all the money that you work for. I don't know what's his obsession with that. Obsession is a good word.
I don't have any obsession with money.
But we must say thank you very much to Attorney at Law Ronald Burch-Smith. Very interesting things that came out here this evening with regards to your rights as somebody who's a suspect, and if you know that you've been arrested for anything, you could ask for a lawyer. You have that right, and of course you don't have to give any statement. Wait until your lawyer is there and she or he decides whether you
But
should.
importantly is if the police have you in the station and they're right to taking a statement from
You
you,
don't have to sign
you
it.
have your relative, you have the
Yeah.
right to have your relative,
Right, and
your
you don't have to sign
girlfriend.
anything. And so, ladies and gentlemen, make sure that you take care on the roadway. And I would want to say, first of all, thank you very much to Attorney at Law Ronald Burch-Smith. Interesting points that he has raised, and of course to my co-host Freddie Kissoon. Please be safe on the roadways, and we're going to be back with you on Wednesday. Interesting times. I think it is. We're going to have one of the regional chairmen who's going to be here to talk about local governance, among other things. So in the meantime, you take care, stay safe. Until then.